and this honorable court. Be seated.
Good morning. We're happy to be back in the courtroom. It's the second time I think we've sat here since we started last month, back in person. So we're having to relearn everything ourselves here. If you would call the first case, please.
Paige, Winiger, Jerry Winiger.
Good morning, Your Honors.
Good morning.
May it please the court, could I please reserve perhaps 4 minutes for rebuttal?
That'll be fine.
Thank you. I'm Jessica McAfee. I think I've appeared in front of at least one of Your Honors before, from the Greenville Bar, and I practice with my husband, Joseph McAfee, and I'm representing the appellant, Paige Wininger. She is the appellant who is appealing the order of the trial court dismissing her petition for order of protection. And while I'm confident that you've had an opportunity to read my brief,
Counsel, if you would, you know, mind
Speak.
standing
Yes, sir.
in front of you.
Thank you. I apologize. I don't want to belabor the same points that are in the brief, obviously, because I understand y'all have had an opportunity to read the brief, and so certainly I'm here to answer any questions, but to maybe take a moment to point out some very important issues that I've raised in my client's appellate brief. In particular, I raised an issue of jurisdiction, that being that the trial court was divested of jurisdiction to hear the matter of the petition for order of protection. And while certainly I recognize that Ms. Winiger filed or, made application for an order of protection, and so perhaps there's even a statement or thought that she couldn't now go back and say, well, Judge, even though I filed it, I don't want you to hear my case. I would simply argue to Your Honors that she filed it there after the party's minor child had been removed from her, and the court had already exercised jurisdiction, albeit improperly so, in our opinion. And so the only way to put the court on notice of the reasons for the separation by the parties and the issues between them at the time was to also make the trial court aware of the underlying domestic violence between the parties. So it was certainly a strategy, but it was also true, at least from my conversations with my client and our strategy on how to proceed. And we did not ask the court to put a protective order over the child, although certainly in many cases a child subject to abuse in a home would be a protected party, and the applicant can ask the court to protect the child as well. But because the chancellor in our case had already made an order in a companion custody case that the father initiated, I did not want to confuse the issues or lose credibility, quite frankly, with the court by trying to go in and kind of sideswipe his order from 2 weeks prior.
Ms. McAfee,
Yes, ma'am.
in the petition that your client filed, she did in fact put in the petition that she was a resident of, I can't remember what county we're in, Washington, or...
I probably ought to know that, Judge, but I can't recall. She did live there.
She put in the affidavit that in the county that she filed it in.
Yes, ma'am.
She was a resident of that county, correct? She listed an address for that county.
She may have listed an address at the time.
She did.
Okay.
And that sort of waives the issue of personal jurisdiction, does it not?
It does on personal jurisdiction, yes. In fact, it's not going to help us to keep belaboring that point either, because she did reside in Washington County. That's not actually in dispute for a period of several months before this action was filed in Washington County, Tennessee. It's just at the time it was filed, literally on the date she had relocated to Georgia for something like 5 to 7 days before all of this litigation with the child, and then certainly the order of protection was heard in court. And then she relocated even after that to South Carolina, so there was sort of moving happening certainly with Mom. And so it's not so much the personal jurisdiction, if I may, focus more on, it was the subject matter jurisdiction. And in particular, with regard to a petition for order of protection, my understanding is, at least with regard to venue, is certainly you should file in the location where most, or the acts, but most of the acts occurred with regard to domestic violence, or your basis for seeking an order of protection. And I made that clear to the court and it should be reflected in the transcript, that most of the acts of domestic violence occurred in South Carolina, where the parties last resided together up until the date of their separation in May of 2021. And there was one incident that I can recall that did happen in Jonesboro, which was Washington County, Tennessee, where this petition was filed at a Texas Roadhouse restaurant. But this incident, according to the trial court and its findings, was not proven and didn't happen, quite frankly, is at least the words of the judge when he dismissed her petition for order of protection. And so, certainly, if y'all want me to move past the jurisdiction just so we can focus on the main gist of the case, which are all the incidents of domestic violence that my client focused on, I think that they're clear in the 22 colored photographs in the record that show all of the various bruising and serious bodily harm that she suffered at the hands of her husband. And while I also recognize that our case law and even Your Honor's job is to make sure and give deference where it's due to the trial court about credibility determinations by witnesses who testify before the trial court so that he can observe their demeanor and perhaps hostility, things you can't always see in a transcript. I understand that's sort of a problem when I'm asking you to go back and say, well, just because the judge didn't find her credible, I want you to, and I realize y'all can't look at that, but I would.
Why should we? I mean, to explain why here we ought to come to some credibility determination other than what the trial court did.
Because the court didn't look at all of the pictured photographs, and even when you compare the pictured photographs with the testimony of both litigants, the husband does not disprove or rebut or refute all of the pictured photographs, but more importantly, not just the photograph, but the testimony that went along with them. And if I may, the easiest way for me to sum up what happened in front of the trial court as far as credibility goes, I think that it's very unusual for the court to understand why my client would have left an abusive husband after acts of abuse in a marriage, separated from him, and then several months later met up with him at a hotel where they had intimate relations. And then this was all while she claimed she was scared of him and afraid of him. And that act occurred, I want to say, in August of 2021, about a week or so prior to the last time they had contact with one another and the child was present before the dad instituted the emergency custody action. And all I'm saying is I think that it's problematic for the court to understand why she would go back to her abuser, if I'm just being kind of blunt about it. And I didn't have a professional or therapist testify about why women or even victims who may not be women of domestic abuse return to their abuser, but I will say that there's plenty of evidence out there about why these type of things happen, and my client testified about why she went and met up with him. He wouldn't give her the child tax credit unless she agreed to have intimate relations with him. That was her testimony at the trial. So she did that so she could keep the child in her care and custody, and because she needed her part of the child tax credit. So
I'm not sure that the trial court simply relied on that one incident. There were I think there was other evidence that was indicative of that supported the trial court's determination that she was not abused, such as the text messages and Snapchats and things of that nature that indicated that she was wanting to reconcile with him. And
thank you for bringing that.
How do you address those?
Yes, ma'am. I appreciate you bringing that to my attention, because I understand, too, that when there was a plethora, I mean, a pretty good chunk, I don't know exactly how many, of text messages provided by Ms. Cook on behalf of the father that I subpoenaed from him, and then she subpoenaed some from my client, but nevertheless, they were introduced in the record. It seems as if husband's argument, or at least his lawyer at that time's argument, and the trial court's opinion seems to be that if they aren't fighting in texts, then there must be no fighting, or if they're not fighting in Snapchats, there must be no fighting. But all I can say to that is the fact that you don't fight in text doesn't mean you're not fighting at home. The text messages and the Snapchats certainly do not reveal 24 hours in any day, every single day.
But it is, I mean, it's relevant evidence, though, isn't it?
Certainly.
Inclusive, but it's certainly nothing wrong with the trial court considering that, is there?
No, I didn't object, no, sir. I think it's relevant to help him understand. Even I, in custody cases, like to look at the whole picture, not just what maybe our clients tell us. But I think that it goes deeper, quite frankly. It goes again to this notion that she, and you can hear it even in the video, or excuse me, audio recording that he introduced, which is another sort of point of contention in our appellate brief, that I think was in error because it was 3 years old, and therefore not relevant, at least in the terms of time frame, to decide that she shouldn't have the kid and to further justify him letting the child remain with dad, but also that she perhaps initiated the acts of domestic violence or that she was at fault in some of their conflict. And I'm sorry, I just lost my train of thought. Let me get back on that. So there was the...
I'll help you by asking.
Yes, ma'am. Yes, ma'am.
When we're considering credibility, or we're looking at the trial court's determinations of credibility, I think one of the things that the trial court focused on, or at least opposing counsel focused on, was the timing of the petition for order of protection, which occurred within days of the husband getting emergency custody of the child. And so the argument was, you know, if you have all of these years-old allegations of domestic violence, why did your client wait until, you know, I mean, the argument is it looks strategic to deal with the custody issue. What is your response to that?
I cannot dispute what is and the timing of things. Certainly, if we could go back in time and she'd had me, not to be bragging as an attorney, I would have advised her a lot differently in the order of things and the timing of things and where a certain litigation should have been filed. But I think she testified that she spoke with one lawyer before all this happened, before she retained me as her counsel, and that was that she didn't think she could file a petition for order of protection in Tennessee because a lot of the acts occurred in South Carolina. But also, I would point out that they had this separation agreement that I think I've mentioned in the brief. I realize it's not necessarily totally relevant for our appeal or the order of protection about the child being able to stay with her, so she felt comfortable with the status quo, so to speak, because they had made their arrangement in writing that the child would remain with her. Thank you. I think I'm out of time.
Any other time for vote?
Thank you.
Hear from the appellate.
Good morning, Jason Creech of the Washington County Bar, here for the appellee. And when this appeal was handed to me by my partner and said, would you handle this, the first thing that occurred to me was, who files an appeal of a dismissal of an order of protection? I mean, that's just incredibly rare. I don't know if I've ever seen it before. And why are we here when there wasn't even enough to give an ex parte order? As you can see from the technical record, the trial court didn't even think there was enough to issue a temporary ex parte order. And by statute, all you need for that is good cause that a, quote, immediate and present danger of abuse to the petitioner exists. So that wasn't even found by the trial court based on the allegations. So why are we going through this exercise? And then once I read the transcript, the first 25 pages of the transcript gave me a clue to that answer, and that is, this is not about an order of protection. The order of protection is a subterfuge to have leverage and influence on these other cases. Again, the first 25 pages of the transcript, there's discussion of this corollary custody matter that was filed by the appellee. There's discussion about a divorce that's filed in South Carolina. There's discussion about a order of protection also filed by the appellant in South Carolina. And as Justice Davis pointed out, this was on the heels of a custody filing by the appellee. So obviously that raised my antenna as to, okay, well, there's more to this story than what is directly before me. And then the appellate process, this became much more clear and in focus, and I applaud my opposing counsel for her veracity and forthrightness, because she's made sort of no bones. This is not necessarily about the order of protection. She filed a motion to consolidate this appeal that we're having with another appeal that they filed under the custody matter. If you go back through our record here just on appeal, she wanted this court to hear this matter along with the custody issue under E 2022-00306. And in their brief, they, on page 16 and 17 highlight what, again, Justice Davis was pointing out when she says, quote, "For strategic reasons, mother determined that if the court determined that mother was a victim of domestic violence abuse, then the court would have jurisdiction on an emergency basis to protect the interest of the minor child." So, and then again, on page 16, one page prior, she says she felt like the only plausible way for the judge to learn that the person to whom he gave custody of a 2-year-old to was not, in fact, a good person to give custody to. It was not in the child's best interest. So, quote, "Mother reluctantly moved forward with her petition for order of protection." So again, the whole jurisdictional question is a little bit of an odd bird to me now because, again, it was her petition, and clearly subject matter jurisdiction for a chancery court to hear an order of protection is defined by statute. What she's really talking about is venue. That's a separate issue. But so this whole hearing had undertones that have nothing to do with domestic abuse. It had legal strategy and a long game in mind. So I had, after just the first 25 pages of the transcript, had very firm reason to be skeptical of this case and this appeal, because if you put yourself in the trial court's shoes now, he was presented with a he said, she said exercise with allegations that go back some 4 years. The very first incident she alleged in her petition is from December 2018, where they're arguing over their cat. And then it proceeds, so every other month there's some incident, there's a lot of discussion about their personal, intimate life. And then they separate May of 2021, which I think is an important date, and the court should draw a kind of a line in the sand, because you heard appellate argue that she was comfortable with that status quo, that they were separated and the child was with her. But from that date forward, we can look at her actions to see what her true intentions and her true demeanor are, and she continues to communicate with appellee. They have, flirtatious digital communications, sexting, along with the discussions of the mundane things of life. And then again, in August 2021, she does seek out his company. That's not listed in her petition for obvious reasons, but she seeks him out, goes to see him at a Red Roof Inn. She is so traumatized, apparently, by years of abuse that she stops and gets a Little Caesar's pizza for them to enjoy. He brings the wine. She wears a nice dress. Things progress as they do with married people. They describe it as a romantic encounter at one time. And then she gets on the stand and says it's a rape. And then in her brief, she says, well, I did it because I needed the tax return. But then again, also she says, well, if it kept him from taking my child and, quote, killing me, then that's why I had intercourse with him. Well, and then another time she says, well, he filled me with wine, even though there's certainly no indication that she was anything other than a willful consumer of 2 glasses of wine. And then another part of the transcript, she says, well, I had intercourse with him because he, quote, told me I had to. So by my count, I've got 4 different stories to excuse away an incident that the trial court found very disconcerting, I guess, given how strong his opinion was, but certainly it puts her testimony in a very odd light.
Counsel, let me just add,
Yes.
before your time runs out, something less interesting perhaps, but the subject matter jurisdiction.
Correct.
What do you say to your opposing counsel's argument on that? Not personal jurisdiction.
Sure.
Subject matter jurisdiction.
Well, what subject matter is the ability of a court to hear a certain type of case. And that is conferred by statute. In our brief, we pointed out the statute indicates that the circuit, chancery, juvenile, all these courts that have jurisdiction to hear domestic matters have the jurisdiction to hear this type of case. So subject matter jurisdiction was well within the chancery court's purview, because by statute it meets the definition of the type of case the chancery court hears.
That argument could have been filed in any court across the state that had that type of jurisdiction.
I believe so. I believe she could have filed in circuit. She could have filed in general sessions.
In Shelby County?
Well, that's a venue issue. That's a separate issue. So if both parties consented to hearing it in Shelby County, that would certainly be inconvenient, but it would be possible. The parties can waive jurisdiction. Waive venue. They cannot waive subject matter jurisdiction, obviously, but the parties can waive venue. So venue was waived. She chose the venue, and she waived personal jurisdiction by showing up. She can't now come back and say the court didn't even have the right to hear this entire type of case. That's beyond the pale, and I don't think allowed under our law. As Your Honor noted, the timing of the filing was 2 months after this romantic endeavor, and only 1 month from the last alleged incident, which was September 8, 2021, this dinner at Texas Roadhouse, where, as we understand from context of testimony, they're separated, they meet to have time together as a family, and there's some alleged comment made, and he, quote, twirled his dinner knife, I guess, and she was so traumatized by this, what does she do? They go to the park together afterwards, like a cohesive nuclear family, and nothing happens thereafter. And again, if the petition is to be believed on its face, this woman who's so traumatized by years and years of violence and abuse and, quote, rapes, that a dinner at Texas Roadhouse was simply a bridge too far. And I just don't find that credible, nor did the court. And I don't want to, again, go through all of the points with 5 minutes left, but the court had plenty of evidence to understand that the preponderance of the evidence standard was not met. The audio recording certainly gave the trial court a window into the context that's important to understand. If Your Honors listen to it, you'll hear a woman who's out of control, screaming, threatening self-harm, unstable, and that recording buttressed and supported the appellee's testimony that indicated this is a woman who has some problems and has situations where her lack of self-control goes beyond the pale, including self-harm. And there are instances he detailed and went almost blow by blow, if you will, where she says, I have this photo. And he says, yeah, I remember that incident. Here's what happened. And was able to recount to the trial court the full context, the breadth and width of the situation where this is a woman who loses control, and he has to physically restrain her. And if you look, her testimony is so exaggerated and so hyperbolic. In 33 pages of testimony, we have the most unbelievable series of testimonies. Again, to believe the petitioner is to believe that she's been cut, stabbed, punched in the abdomen after a C-section, raped repeatedly for years. And then we have this recording, we have exhibits 19, 20, 21, we have the testimony of the husband that put some context. We have even a discussion about her mental health history that included a hospitalization. We have discussion and testimony of the reason why he filed the custody matter in the first place, that she took off with the child. And she testified, I was afraid because he had exposed us to COVID. So that's why she had to abscond with a child. That's page 56 of the transcript. So to your point, the trial court was in the best position of all of us to look at these facts, to look at the parties, assess their credibility, and he certainly found the appellant's credibility lacking. In fact, this wasn't a ruling by the trial court that said, you know, this is a close call, I'm having a hard time going back in the past. This ruling was a strong ruling where he said she's not a victim, she's unresponsive, deceptive in her answers. Basically, her actions in the proof are absolutely contrary to what her testimony is. And he went so far as to say she needs professional help, which I would certainly concur. Now, appellant's argument today is, hey, we've got pictures. Therefore, the court must have or should have given an order of protection. That's simply not the way reality works, and that's certainly not the way the statute works. She had the burden of proof to prove her allegations beyond a preponderance of evidence, and there's simply not enough evidence here. And in fact, the counter evidence was so strong that the trial court gave an opinion that I thought was very, very direct. And I see no reason for it to be disturbed on appeal, and we're asking that you affirm the dismissal.
Thank you. We'll hear from the appellant rebuttal.
I think I addressed this in our brief, but just to quickly go over it again, the reason we are appealing the dismissal or denial of the petition for order of protection is because in South Carolina, their divorce laws and the way that the divorce judges handle their cases is you can't go into court and get a divorce and argue grounds, specifically domestic violence, if you've already been to a court and that issue's been litigated. So the issue at this time is res judicata on any issue of domestic violence, but more importantly about whether she's a victim or not a victim is how it relates to the custody matter. She's going to be precluded, at least this is my understanding from speaking with her South Carolina counsel at the time, and her as well, that she's going to be precluded from using any acts of domestic violence or other types of acts by the husband that could be in the category of domestic violence against him to try to seek any type of custody of the child, which they're still in litigation pending right now in South Carolina. So it was to protect her right to continue and get a divorce from this man, and also to be able to try to fight for her kid, quite frankly. So I thought that was enough of a reason to at least try to keep the issue where it wasn't a final judgment and keep her from being able to argue that in the court. I did try to get the court to get an ex parte order, obviously, but of course you can't talk to the judge when you do that. You just go to the clerk's office and you file your form, and we did provide the colored photographs. I obviously don't have any understanding or knowledge of why the judge did not sign the temporary order. I just know that it was in the days following him signing over custody to Dad, stating that Mom had evaded service in the custody case, and so he just declined to enter any type of ex parte order and asked that I set it on the docket along with the hearing for the motion I was requesting a hearing on, which was the custody due to an ex parte order that the court signed on Dad's ex parte motion. And that was 2 weeks later that we got to set a court date on that. So I don't really have any specifics about why the court didn't sign off on the ex parte order, but certainly the record reflects he did not do so. There was never an ex parte order entered, so it was just set on the docket, so to speak, about 14 days later. I didn't get to mention, and I just want to briefly discuss at least part of an issue about the evidence, which is the evidence that didn't come in. The evidence that, in my view, and in my client's view, would have made it easy for the judge to then determine which party was to believe, and perhaps he felt very confident in his decision to believe perhaps the husband and his testimony over my client, and that was the audio recording, which was in 2021, in the months prior to their separation, that he didn't allow me to enter into evidence. Now, I made an error when I didn't proffer that to him. We just didn't discuss it. I mentioned that I had an audio recording and I had to access it through email because my client had sent me a data dump, quite frankly, of tons of emails with texts and videos and audios, and I attempted to access it via email on my computer to play in the courtroom, and I did not provide that audio recording to opposing counsel, which is the basis the court didn't allow me to play it. So I don't know how appropriate it would be for me to make a proffer now, because that didn't happen and it's not part of the record. All I can state is that I believe that the court, in not allowing me to play the audio recording, which would have made a critical difference because it was evidence in and of itself of domestic violence, was enough error that it would change the outcome. There's no question about it, because the husband is in it and the wife is in it, et cetera. And I don't know that our local rules in Washington County would have precluded me from entering it either, nor would the rules of civil procedure. All right, thank you.
Of course, thanks to counsel for both sides. I appreciate your arguments this morning, as well as your briefs. We're going to take a short recess here so we can move some judges around before we call the next case. Thank you.
All rise.